The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, this morning we're going to conduct the court with a full 3 judges, but Judge Diaz is going to join us on the television screen. You see him there. Good morning, Judge Diaz.
Good morning, Judge Memark.
So we'll hear the first case of United States versus Manley, and Mr. Ballinger, we'll hear from you.
Thank you, Your Honor. May it please the court. I'm the director of the Appellate Litigation Clinic at the University of Virginia School of Law, and it's my pleasure to introduce 2 law students who will be presenting argument for Mr. Manley. Jacob Smith will handle the opening argument, and Holly Chason will handle any rebuttal.
Okay, thank you. And we'll hear from Mr. Smith first.
Thank you, Your Honor, and may it please the court. The core question here is the one the Supreme Court reserved in Borden: whether extreme recklessness counts as a use of force against another. It does not. Mr. Manley's 924C convictions should be vacated for 3 reasons. First, extreme recklessness does not satisfy the 924C force clause. Second, the Vicar offenses can be committed with extreme recklessness. And third, the Virginia predicates are relevant under this court's recent decision in Simmons. Addressing the extreme recklessness issue, the Borden plurality drew a stark contrast between defendants who intended harm or knew that harm was—
You're jumping ahead a little bit. Let me just see if we agree on some ground rules. Under 924C, we're trying to define a crime of violence, right?
Correct,
and
Your
in
Honor.
doing that, we use a categorical approach to look at the crimes of violence that are alluded to. And in this case, with respect to the assault, that's set forth in a separate count, alleging assault under a Virginia statute. Isn't that right?
Not quite, Your Honor. It's assault with a dangerous weapon under Vicar.
Well, it's a Vicar violation, but the Vicar violation is a violation of state or federal law, and it defines a state law. It actually gives the citation to the state assault.
That's right, Your Honor.
Okay, so we don't look at the facts. We just look at what the allegations of these statutes say and determine whether they're crimes of violence. That's what we're looking at, right? That's your argument now, to get to where you were beginning your argument. Your argument is that some violation, I don't know if it's a Vicar violation or the state violation, can be violated with extreme recklessness. And so maybe you can begin there and tell me which statute you're addressing, and then we can go on from there.
Certainly, Your Honor. To discuss the Vicar offenses, it's pretty plain they can be committed with extreme recklessness. The government admits on page 30 of its brief that generic murder can be committed with extreme recklessness, and that aligns with what 5 circuits have held.
Well, shouldn't we be looking at the text of the Vicar to determine? It says whoever for the purpose of obtaining money or the purpose of advancing himself commits an assault.
That's correct, Your Honor.
If you're committing assault for the purpose of getting money or advancing your position, isn't that intentional?
No, Your Honor, because while there's a purpose required, the criminal acts committed with that purpose could still be reckless. And that this—
How is it if somebody says, I'm paying you $10 to go shoot the legs of my opponent, and you go there and shoot the legs of the opponent, and he gives you the $10? Can that be reckless?
Not in that example, Your Honor. But
well, I'm trying to put in the purpose. It says for the purpose of achieving position, advancing your position in the enterprise, or for money. Right?
Right, Your Honor.
All right.
But there are cases where you can think of a getaway driver for a racketeering organization. He's acting for the purpose of maintaining his position in the organization, and in doing so, he drives very recklessly, he speeds, and he kills someone, and he's convicted
He's
of
not driving recklessly for the purpose of the enterprise. He's driving recklessly because he's within the enterprise. But here, the conduct of assault has to be committed for payment, or it has to be committed to advance your position, doesn't it?
Your Honor, the conduct, the criminal conduct has to be committed for that purpose.
Yeah.
But it doesn't necessarily follow that the result element has to be committed for that purpose. And the Second Circuit actually addressed this question directly in the 1999 case, United States versus MAP. And they recognized that Vicar felony murder was possible. And they took that same line of reasoning that you look at the criminal conduct that's punished, and you don't necessarily.
Well, the violation of an element of the Vicar violation is it has to be for money or to advance your position. Unless you have that, you're not violating. But let me take it a step further. The Virginia statute says you have to assault with the purpose of maim, personal injury, and all that. And we've held, in Rumley and other cases, that's a violent crime.
Your Honor, to respond to that first, we believe the Virginia offenses are means and elements of the Vicar statute, so they ultimately aren't relevant. But further, to address Rumley, that decision assumed that the mens rea was intent, but it didn't look at how Virginia courts interpreted the intent element, and the government's admitted that Virginia murder can be committed with extreme recklessness. And once that's admitted, it does follow that unlawful wounding in violation of 18.2-51 can be committed with the same mens rea. That's because Virginia courts have held that unlawful wounding is the same mental state element as voluntary manslaughter, and manslaughter is a lesser included offense of murder. So if murder can be committed with extreme recklessness, unlawful wounding certainly can as well. And Rumley did address the same crime. We admit that, and we admit that is a difficult issue. But it's clear in this circuit that an unchallenged and untested assumption is simply not one that controls future courts. That's what the court said in United States versus Norman.
But to the issue of whether we are looking, let's talk here with assault with a dangerous weapon on that aspect of the offense. I think I understand you to say it's irrelevant that count. Is that one 20? Is that 25 or 35?
The assault one is 25, Your Honor.
Yes, but it references count 24 in the indictment. And count 24, as Judge Niemeyer, I think, alluded to, specifies the Virginia statute. So why wouldn't we look to the actual using the modified categorical approach to figure out, as much as we can about what offense to apply the charging documents, or what offense to apply a categorical approach to? Why wouldn't we look to that?
Your Honor, because the Vicar statute is indivisible on its face. The element is in violation of the laws of any state or the United States. It doesn't set out a list of alternatives. And under Supreme Court precedent in Mathis and in Decomp, that's where the modified categorical approach stops. If there's no list, it's indivisible. And this circuit recently addressed a directly analogous situation in Simmons.
That's the RICO case?
Yes, Your Honor. In that case, the court said RICO conspiracy is divisible into conspiracy and conspiracy aggravated by racketeering activity, but the racketeering activity element, that's not further divisible based on all the possible racketeering activities. And that was the case, even though in in Simmons, there was a statute that set out all the possible racketeering activities.
But to your point, and you laid this out at the beginning, I mean, it's arguable perhaps that some of these defense require intent or knowingly. You resist that, and I appreciate, I think your argument's there. But you concede that they require at least extreme negligence, correct?
Yes, Your Honor.
Has there been a circuit court, a court of appeals since Borden that has found extreme recklessness was not a crime of violence?
No,
all the circuit courts have addressed it, have found that it was, correct?
that's correct. To address that, where we believe with respect that the Ninth Circuit and the First Circuit went astray is that they relied on the fact that an extremely reckless defendant is aware of potential victims. But that's true of ordinary recklessness too, so it doesn't really distinguish the two.
Well, they make a difference. I mean, that all the examples, and in fact, the Supreme Court, well, let's just talk about those cases. That it seems to me they indicate that in the case of extreme recklessness, you're aware of, potential victims in a much more concrete setting. In other words, there's people that are known to you. You may not, in the extreme recklessness, target person A, but you have a group of people who are visible, known, and which is different than the person I think that Justice Kagan talks about, who is late for work, goes through an intersection and hits someone that the driver doesn't see. So it seems like there's this question in the extreme recklessness conduct of, do you have to target a specific individual, or do you have to be aware of people that there's an extremely high likelihood will be either injured or killed?
Your Honor, extreme recklessness requires heightened culpability, but it still doesn't require targeting particular persons. And driving offenses are a great example. For example, in United States versus Fleming, this court considered a defendant who drove at very high speeds, who was weaving in and out of traffic. He took a curve too fast and he killed someone, and his conviction for second-degree murder was upheld. That's a situation where the defendant certainly didn't intend to use force against anyone. He certainly didn't know it was practically certain that he would use force against someone, or he would have stayed home. You
think that's analogous where somebody did not intend to kill, but his extreme recklessness was in driving the vehicle? You think that's analogous to a circumstance where a person assaults for the purpose of money, receiving money, or for the purpose of achieving advancement in the enterprise?
Yes, Your Honor.
He actually assaults for that purpose. I don't see how that could be reckless. He set about to assault for the purpose of obtaining money or for the purpose of advancing himself in the enterprise. And those are elements of the Vicar statute.
Your Honor, as in the example of someone who's driving for the purpose of...
Now, I'm trying to point out that analogy doesn't work, because you're not driving for the purpose of killing somebody. You're driving to get away, and you're reckless while you drive and kill somebody. Here, you're assaulting somebody for the purpose of money. You're assaulting somebody for the purpose of advancing yourself. That's the allegation. Those are the elements right in the statute. Uses those words.
That's correct, Your Honor, but Vicar incorporates the generic definition of murder, and it does so without altering it in any way.
But you are overlooking for the purpose of. In other words, it doesn't take the whole range. It doesn't say necessarily reckless or negligent homicide. It says you're committing an assault to receive money, or you're achieving it to advance purpose. I don't know how that could be more deliberate.
Your Honor, the assumption seems to be that the purpose element has to map on to the result element of the generic crime.
Exactly what the statute says: anybody who assaults with a dangerous weapon for the purpose of gaining entrance or maintaining an increasing position.
Your Honor, these generic definitions, they come with their own mens rea. Murder has a very well-established mens rea that includes
So if,
felony.
if somebody pays you to assault somebody and you assault them, you think that's reckless?
No, Your Honor, but we can imagine situations where a person would receive consideration to do something reckless, and then that would end up resulting in assault or resulting in murder. I see my time is expiring, so.
Counsel, before you sit down, I have a couple of questions. So I get your argument that you don't think that we should consider the Virginia enumerated offenses because you think they're means and not elements of the Vicar offense. But assume for the moment that we don't agree with you. Judge Niemeyer raised this point, and I think Judge Quattlebaum did as well. I mean, if we're looking at those offenses, specifically with respect to assault with a deadly weapon, you know, it's the three cases that you cite in your brief. Ultimately, don't those cases look to circumstantial evidence of the behavior in question to make out the specific intent? And if in fact that's true, aren't the Virginia cases in fact consistent in requiring specific intent with respect to the assault offense?
Your Honor, I see my time has expired. May I briefly answer? Your Honor, if you read the cases, you see that they do use the language of recklessness. And further, as I mentioned earlier, it's clear that unlawful wounding has a similar mental state to murder, which the government admits can be committed with extreme recklessness. We respectfully ask the court to vacate Mr. Manley's 924C convictions and remand for resentencing. Thank you.
Hold on, don't sit down just yet.
Sorry.
So with respect to the Virginia murder offense, let me ask you this. So do you agree with me that under Borden and under the statute with respect to 924C, what matters is the defendant's intent to use force and not necessarily cause death?
Yes, Your Honor, because that's what the force clause asks for, if I understand your question correctly.
Right. And so again, going back to the Virginia statute with respect to murder, because of course, generic, you may have a valid argument with respect to generic murder, but ultimately, if we don't agree with you that the enumerated offenses in the Vicar statute are means or elements and not means, if we think they're elements, then we look to the particular statute in the way it's been interpreted by the highest court in the jurisdiction. And in Virginia, anyway, the Virginia Supreme Court has required the government to show willful or purposeful behavior rather than negligent behavior. In other words, that the defendant embarked upon a course of wrongful conduct that was likely to cause death or great bodily harm. So doesn't that map on neatly with Borden's requirement that what matters is the defendant's intent to use force, not necessarily cause death?
No, Your Honor, and in respect, I think this is where the 11th Circuit may have gone astray in Alvarado Linares. Intent to do something that's in some sense harmful or wrong simply isn't the intent to use force against another that Borden requires.
All right, thank you.
Thank you, Your Honor.
All right, thank you. Mr. Ms. Becker.
Good morning. May it please the court. Jacqueline Bashara for the United States. In both Irby and Bryant, this court cited the Supreme Court's approval in Johnson 1 of a definition of a violent felony as a crime characterized by extreme physical force, such as murder, forcible rape, and assault and battery with a dangerous weapon. In this case, the defendant's 924C convictions are validly predicated on 2 violent crimes in aid of racketeering.
I guess just to cut a little bit short, the argument that Mr. Smith is making is that Borden might have changed the landscape. but in any event, it's the most recent, and it adds the mens rea requirement analysis. And so you may be right in those statements, but it seems to me Borden's very relevant, isn't it?
Of course. Your Honor, Borden simply maintains the status quo in this circuit. As the defendant acknowledged at page 10 of his reply brief, this court held as early as 2006 in Garcia versus Gonzalez that crimes that could be committed with ordinary recklessness do not satisfy the force clause. And so to credit the defendant's position would suggest that the court simply ignored its own precedent for 15 years before the Supreme Court handed down Borden. But we know that's not the case because there are cases where the court specifically decided that various offenses did not satisfy the force clause because they could be committed recklessly, such as the 2019 Simmons case or the concurrence in Middleton. There are other cases where the court analyzed the mens rea required at length in cases like Burns Johnson and Townsend. And again, those all were decided before Borden. So this principle was necessarily operating in the court's crime of violence cases.
Counsel, that's I think fair, but from my memory, Bryant and Irby don't discuss the mens rea issue. They're focused more on the force, that is required to commit it. That doesn't necessarily mean they're overruled, but it doesn't address this issue we have now of extreme recklessness, to the extent that's, the mens rea for some of these statutes. So what's your position with respect to extreme recklessness?
We maintain that as every court of appeals that has addressed extreme recklessness as a mens rea, it continues to satisfy the force clause because as the Ninth Circuit, the en banc panel of the Ninth Circuit in Begay explained, extreme recklessness requires extreme indifference toward the value of human life. And at least in the context of murder, the Ninth Circuit adopted the First Circuit's reasoning in Baez-Martinez, which is that the killing of another human being with malice aforethought is conduct that is necessarily oppositional. That's the key word from Borden, because a defendant certainly must be aware that there are potential victims before he can act with indifference toward them. If I may.
So let me just, go a little further there or talk about that a bit more. So, in some of the reckless driving examples that we were talking about with your colleague, there's an awareness of potential victims there. And Borden uses the language, to target an individual. And so it seems to me, the question, and you're right, all the other court of appeals that have addressed this have said it's satisfied by extreme recklessness. But is there actual targeting of an individual with extreme recklessness?
Your Honor, I'd like to make sure that we can keep in mind, despite that targeting language, Borden made clear that it is not only intentional specific intent crimes that will satisfy the force clause, right? We know because the plurality said that knowledge is enough, and because the plurality carved out an exception for extreme recklessness. Indeed, the en banc panel of the Ninth Circuit in Begay actually held that Borden abrogated the Ninth Circuit's earlier precedent to the extent it suggested that only intent crimes satisfy the force clause. Now,
I hear you. I think I understand that, but you still need to deal with that language. And it seems like it either means you have to have in your mind, I'm going to hurt or kill an individual, or it means you have to have an awareness of, individuals that are highly likely to be hurt or killed.
Right. So I would urge the court to consider a phrase that recurs throughout the plurality's opinion, which is that the against phrase in against the person of another introduces the conscious object of the force. And we maintain that in cases involving extreme recklessness, there is always a conscious object. Importantly, we can consider the driving examples that Justice Kagan offered in her opinion, which tease out this distinction very helpfully. As I believe Judge Quattlebaum flagged, the recklessness example was that someone who's just running late to work and doesn't see a person in their path hits that person. That's ordinary recklessness. But let's say a getaway driver speeding away from the scene, sees someone in his path, right? That is a conscious object, plows forward anyway, and that is knowledge. And we believe that extreme recklessness is approaching knowledge. It's quite close to that because even in the driving examples where courts have upheld a finding of malice, those all involve situations where the driver at least appreciated that there was someone in his path. It wasn't a mere accident.
Going further in that portion of the opinion, Justice Kagan talks about the fault of the defendant being inattention. And I take it your position is with extreme recklessness, we're not talking about just mere inattention. We're talking about wrongful conduct with people that you're aware of.
Exactly, Your Honor. I'll bring us back to the decisions that we already have on this. Every court of appeals has emphasized that extreme recklessness requires indifference toward human life. That is necessarily oppositional, and there is a conscious object of that force. If I may, I would like to address a few points that my friend made. First, we maintain that this court's inquiry in this case is shaped by its decision in Keene, which held that a vicar conviction from the text of 1959 requires that a defendant's conduct constitute one of the enumerated federal offenses as well as a violation of the charged state crime. And so there are three relevant components when evaluating the minimum mens rea required for each of these vicar offenses: the elements of the federal enumerated offense, the elements of the charged state crime, and of course, vicar's purpose requirement. This court's decision in Simmons just simply doesn't bear on the inquiry here because the court was interpreting a different statute, that is 1962 RICO conspiracy. And in Simmons, the court explained that a RICO conspiracy offense is completed when two people reach an agreement to commit two or more racketeering acts. The racketeering acts identified in 1961-1, as my friend correctly observed, this court determined those are means, not elements, because it's irrelevant to the jury's determination whether the agreement was formed, what the underlying acts were. But here, this court made clear in Keene that a jury must find that the defendant engaged in the conduct alleged in the indictment. So there it was, assaulting the named victim with a dangerous weapon in violation of the Virginia brandishing statute.
But is Keene really on point here? Because here we're talking about a crime of violence under 924, and Keene, as I recall, was about primarily whether you have to do the categorical approach, in assessing the elements of the vicar offense. So maybe I'm trying to see how those two match up. It seems like we're in a different posture here.
Your Honor, because Keene said that a jury must find both that the conduct engaged constituted the federal offense and the charged violation of state law, there is no circumstance in which a defendant could be convicted of a vicar offense without the jury necessarily have founding that he completed the Virginia state crimes charged in the indictment. If the court has no further questions as to murder, I'll turn just briefly to vicar assault with a dangerous weapon based on Virginia Code 18.2-51. As your honors observed, this court already held in Rumley that Virginia unlawful wounding statute satisfies ACCA's force clause because it requires not only the causation of bodily injury, but also the specific intent to maim, disfigure, disable, or kill. And contrary to my friend's position, Rumley remains correct after Borden for at least three reasons. First, Rumley expressly discussed the mens rea required by the force clause, citing Leocal. Second, Rumley relied on this court's previous decisions that had reached the same conclusion, including a case called Jenkins, which was orally argued but resulted in an unpublished decision, and Jenkins discussed the mens rea required by that statute at length. And finally, this court applied Rumley again after Borden had been decided in Moreno Osorio.
What, counsel, what if, yeah, I appreciate your keen position and the need and your view that we need to focus on the Virginia statute. Assume just for a second, we also have to look at the federal assault with a dangerous weapon offense. What's your position as to how that's a crime of violence?
Your Honor, we maintain that Bryant dictates that federal generic assault with a dangerous weapon is a crime of violence because the dangerous weapon element transforms even an ordinary assault offense into a crime of violence. And we know that that reasoning remains sound after Borden from cases like the Ninth Circuit's decision in Buck, which specifically joined Bryant and Knight, the Sixth Circuit case on which Bryant relied, and that was decided earlier this year after Borden. Finally, I'll renew just briefly our argument that these Vicar crimes could not have been committed with a mens rea of ordinary recklessness because every Vicar offense requires proof that the defendant engaged in conduct in the enumerated offenses either for consideration or to maintain or increase his position in the racketeering enterprise.
Counsel, can I ask you a question about the hypothetical that Judge Quattlebaum mentioned that I think Judge Kagan spun out with respect to a motorist who is late for work and travels at a high rate of speed on a roadway, and you seem to indicate that might not rise to the level of extreme recklessness sufficient to warrant a finding that was a crime of violence. So in the Virginia statute, it's pretty clear that the statute on its face seems to require specific intent with respect to the assault offense. But your colleague on the other side points to 3 cases that, in his view, suggest that perhaps the Virginia courts interpret the statute as requiring something less than specific intent. And the one case in particular that I want you to talk about for a moment is the Knight case, where the Virginia Court of Appeals found that an appellant who was traveling at a high rate of speed, at such a dangerous rate of speed, given his surroundings, that a rational fact finder could certainly infer that appellant intended the immediate, direct, and necessary consequences of his voluntary acts. I suppose that finding of intent is sufficient to suggest that perhaps the court is being consistent. But how's that fact scenario different from the one that Judge Quattlebaum talked about? What makes it different?
Your Honor, that case is significantly different, and we believe that satisfies Borden's formulation of a conscious object of the force. And that's because we know the court discussed at length the underlying facts. The defendant in that case was traveling at a rate of, I believe, 77 to 107 miles per hour. It was well over the speed limit in that zone, which was 35 miles per hour. He moved from the ongoing traffic lane and directed his car into the left turn lane where cars were sitting waiting to turn. In other words, the drivers of those cars were conscious objects just sitting in the lane waiting to turn into a shopping center. And moreover, there was testimony elucidated at the trial that the defendant was seen laughing as he turned his car into that lane. So from all of that, the court correctly concluded that the defendant had the specific intent to injure those victims sitting in their cars.
That case was also a sufficiency of the evidence case, wasn't it, as opposed to actually addressing the mens rea?
That's correct, Your Honor.
Thank you.
Anything further?
If the court has no further questions, we ask that you affirm.
All right, thank you very much. Ollie Chasen.
Thank you, Your Honors. A few points. Judge Niemeyer, if the purpose element of vicar applied separately to every element of the predicate offenses, then vicar murder would not encompass either depraved heart murder or felony murder. But the Second Circuit in the MAP case that my co-counsel cited held that vicar murder does include felony murder. And there's no reason to think that Congress meant to.
I didn't quite understand your argument. The vicar says you have to either commit the murder or the assault for the purpose of receiving money or for advancing in the enterprise, advancing your position in the enterprise. Now, the question is, with that, those additional purposes laid on to the assault and the murder, how do you get rid of that?
Our understanding is that it does not map onto each of those elements. It only applies to the conduct at issue, which is murder or assault.
Well, it's sure, but it says the violation, and it says whoever for the purpose of receiving money or for the purpose of advancing yourself assaults or murders. So the question is, why doesn't that read on it? It's a direct grammatical modification of the murder and the assault.
Your Honor,
grammatically.
Your Honor, we think that this court's holding in Simmons that the RICO statute had those two indivisible elements is similar here. It's not that the purpose element doesn't map onto the conduct, it's that it only maps onto the conduct. So the conduct that you commit, murder, has to be done for the purpose of currying favor with your gang. But you can commit.
If you commit murder for the purpose of advancing your position in the enterprise, doesn't that mean you're setting out to do the murder?
Right, but our contention.
You have knowledge of it and you're going to pursue that conduct with that purpose. Isn't that a mental state?
Right, but Your Honor, our contention is that if you are doing another action, such as driving extremely recklessly for the purpose of maintaining or increasing your position in the gang, that you could then commit murder recklessly.
Except the murder is the object, not the driving the car. And your hypothetical takes the driving of the car as the reckless conduct. But my point is that regardless of how you define murder or assault, if the statute requires that you commit the murder or the assault, that's the conduct at issue, the murder or assault, for the purpose of receiving money or for the purpose of advancing your position, I don't understand how the government satisfies those two elements without proof of some kind of mental state.
Your Honor, but we want to argue, like the Second Circuit did in the MAP case, that vicar Congress did not intend vicar to eliminate the possibility of being convicted of vicar, depraved heart murder, or felony murder, which are murders that can be committed recklessly. So our example of a gang member driving a car extremely recklessly for the purpose of impressing his gang buddies to maintain or increase his position in the racketeering enterprise, that would satisfy the vicar purpose. You are acting with that purpose. But then if he then kills someone accidentally because he is driving extremely recklessly, then he could be found guilty of vicar felony murder.
Then you're not committing the murder for the purpose of advancing.
Right.
You're driving recklessly for the purpose of advancing. The question, the hypothetical just simply doesn't read on to the statute. The statute says you committed the murder for the purpose of receiving money.
That's a fair point, Your Honor. I think our focus is that we're focused on the least culpable conduct, and we do believe because vicar murder could be committed recklessly, that Mr. Manley's 924C conviction should be vacated here. And
it would have to be extreme recklessness, wouldn't it?
Correct.
And Borden left that open?
Yes, Your Honor, the Borden court did reserve that issue in footnote 4.
And the courts of appeals that have addressed that issue since
right
concluded extreme recklessness is
correct.
A crime of violence, right?
Correct. Though we do believe the Ninth Circuit in Begay and the First Circuit got that wrong.
Okay, let's assume they got it wrong.
Right, Your Honor.
What do we do after Borden? In other words, if we're facing the same issue those two courts faced,
yeah,
my guess is if Your way would be creating a split. That doesn't mean we can't do it. You know, we hold our own counsel and try to do the right thing. But two other circuits, at least two, have addressed the issue, and we ought to at least look at them. But we have to accept your arguments. I mean, and address it in this case. Why isn't extreme recklessness a violent crime?
Because there is no meaningful distinction for the purpose of the force clause between ordinary recklessness and extreme recklessness. It certainly doesn't require the type of targeting that any more targeting than ordinary reckless driving. It's just in a judgment that
I understand recklessness. The understanding that Borden talked about recklessness, it is the conduct in the face of risk. And the question is, how high is the risk? And when the risk gets so high, it gets close to deliberate. And extreme recklessness, Borden left it open, but I think these other courts thought that extreme recklessness gets close to a mental state that we would call violent. Isn't that really where the recklessness standard is the addressing the degree of risk?
Yes, Your Honor, the distinction between ordinary and extreme recklessness often does involve a higher culpability being assigned to extreme recklessness. But at the end of the day, extreme recklessness is still ordinary recklessness and what it requires. It only requires a conscious disregard of a substantial and unjustifiable risk.
But the, you know, in the Virginia courts that go through that, the Essex case, the Watson Scott case, one other one, I'm drawing a blank right now, but either they tease that out and they use examples where, you know, for example, shooting a gun in the woods, a hunter injures someone compared to shooting into a room. I mean, the latter being extreme because there's known individuals that the force was applied against, whereas in the hunter in the woods situation, you know, there's not known individuals. It seems like that's more like Justice Kagan's example of a, you know, late for work driver who hit someone they did not see. All the examples in Virginia case law seem to talk about, you know, maybe you didn't say I'm going, you know, target Mr. Jones, but the awareness of individuals was so clear that it was, you know, almost certain that you would injure or kill one. Seems like that is the difference, and that, you know, is what the other circuits say, you know, gets us to a crime of violence.
Your Honor, the difference between extreme recklessness and ordinary recklessness is more of an ad hoc moral culpability judgment. This court in Knight found extreme recklessness, and there Mr. Knight actually applied the brakes before he hit his victim. In this court in Fleming, the driver was driving extreme speeds, he was drunk, he weaved in and out into oncoming lanes of traffic and killed someone, and yet this court still only held that extreme recklessness was sufficient to satisfy second-degree murder there. We contend that because of this, extreme recklessness is really not, it really only differs from ordinary recklessness in this ad hoc culpability judgment. And I see that my time has expired, so we would ask that this court vacate Mr. Manley's 924C convictions and remand for resentencing. Thank you.
Thank you, counsel. That's I want to compliment both counsel for the appellants. You argued like mature counsel. We expect you to be here several times in the future and look forward to your arguments. You did a fine job, and thank you for that. Our practice is to come down and greet counsel, as you know, and we're still observing the protocols of COVID. And so we're not going to do that today, but we do extend our spiritual handshakes and thank you for your arguments. They're very helpful. And then proceed on to the next case. Thank you. Oh, go ahead.
Thank you, sir.
And you're free while you're arguing to remove your mask. That's up to you.
Thank you, Your Honor. I will. Thank you. May it please the court, Daniel Peterson for the city of Charlotte, the appellant in this case. This appeal before the court today, of course, involves whether an appellee is a prevailing party under 42 USC section 1988, where the consent judgment dismisses the claims at bar with prejudice and requires both parties to take action as a result of its order. The consent judgment, which is contained in the joint appendix at 528 to 531, from which the award fee appealed from arises, is at best for the appellee a legal draw. The appellee is not entitled to the prevailing party status simply because a consent judgment was used, a sort of per se argument. The court in Buckhannon, for instance, referenced consent decrees may certainly.
The district court listed some of the benefits that the plaintiffs achieved through the consent order. Do you agree with those benefits?
I do agree that the plaintiffs did, as a matter of compromise in the context of the greater litigation, reap a limited benefit in that they can make
several benefits. The court listed several. It wasn't just one thing. I mean, it's a citation practice, what they can do, what they can physically go, where they can physically go. They can apparently violate the earlier interpretation of the statute. The statute wasn't changed, we know. But the court listed those things, and if they received those benefits, that was the reason the court said that they prevailed, at least to a limited extent. And of course, its award reflects its view about the limited extent because it reduced the award substantially. But that's the question, is whether the district court was wrong in identifying those benefits.
Your Honor, I don't believe that the district court was wrong in identifying and itemizing the benefits that were gained in the consent judgment. However, I think it's important in this case, because this case doesn't have a neat fit within our case law, to look at what the plaintiff was ordered to do as antecedent to obligating the defendant, the city, at all, Your Honor. And that is, one, they have to. They were ordered by this court by the district court, pardon me, to approach a vehicle standing on the sidewalk or curb, not to enter the relevant street or the clinic driveway to approach a vehicle unless it comes to a full stop, and then promptly end the approach once some of the very safety concerns that were cited in the record by various Charlotte Mecklenburg Police Department officials occurred, which
counsel, I think I understand that. I think, yeah, that's fair. I mean, one could debate whether that was necessarily contested, but we and I think you're right that this doesn't fit perfectly with any of the Supreme Court or Fourth Circuit cases. But a recent I don't know if it's G or G case, but it lists 4 items, and judgment, consent decree, or similar order. We got consent decree. I'll grant some relief on the merits. That's probably where you're going to focus. I think the other 3 and 4 are met. And so it seems to me we're looking at, does this grant some relief on the merits? Now, it doesn't say, the court doesn't find you prevail on a claim in that sense, but the Supreme Court's told us that's not necessary. So it seems, doesn't some relief on the merits include at least the ability to do something that, as you applied your ordinance before, they weren't able to do? Isn't that some relief on the merits?
Your Honor, I think that where that distinction arises is what was asked for in the amended complaint versus what ends up in the consent judgment. The plaintiffs, the appellees, would not have been ordered, had they played this out through the trial process or even
won summary judgment on their behalf, been ordered to take these steps that are again antecedent to the defendant having to
One
do
of the
something.
things they sought was an as-applied challenge to the ordinance. And why isn't the ability to do the vehicle approaches effectively a result that they could have obtained under that claim?
If I understand the court's question, please correct me, obviously, if I'm wrong.
Yeah, sure.
It's at best, it is a technical result, as that the Texas State Teachers Association case from 1989 in the Supreme Court commented on, that there may have been one slight modification to the state actor's conduct, but that at the end of the day, particularly given the various and sundry claims and requests for relief. And I think it is important, though, that the antecedent conduct has to take place by the plaintiffs before the city has to do anything. That, and I won't beat that drum too much further. I know I've said that a couple times, but I think that's the distinction.
Is there
here.
a case that talks about antecedent restrictions? I mean, you have a case that says when you have those, that somehow negates the benefits?
Candidly, Your Honor, I do not.
No, the Supreme Court's decision in Mayer versus Gagney is pretty close to your case. The court says fees may be assessed against state officials after a case has been settled by entry of a consent decree without any determination that the planned constitutional rights have been violated. And so the only question is is whether there are some benefits. And if you look at the complaint in this case, the complaint is filled with incidents that they think didn't violate the statute and that you were enforcing against the statute. And they were concluding that it was being enforced too broadly. And the consent decree mitigated that.
Your Honor, I agree that is very close to our facts here. I think that,
And of course, Buchanan cited Mayer with approval and repeated the very same language that you don't need to have a determination of the rights at all. You just have to have a consent decree and provide some of the benefits.
and if I may, Your Honor, I
Yes,
think
of course.
the slight, but I think imperative distinction here is for one thing, the consent judgment actually goes out of its way to dismiss all the claims without, for example, retaining jurisdiction over the matter. So it enters it, and as the court knows, often and usually, and I know this isn't often or usually in this case, but a dismissal of claims with prejudice is an adjudication on the merits for the defendant, which seems to be large part of the appellee's argument and reliance on the CRST case from 2016, which we contend have completely different. It memorializes the competing goals of the parties in that the defendants.
Mr. Peterson, can I ask a question? So getting back to this issue of whether the plaintiffs actually prevailed on the merits. So I guess you have to start with the ordinance itself, right? That reads fairly broadly, at least it did when it was being applied before the consent judgment was entered, that prevented the petitioners or the plaintiffs from disrupting, blocking, obstructing, or interfering with pedestrian or vehicular traffic or the free passage of pedestrian or vehicular traffic. And I'm not going to read the whole thing, but it's essentially pretty restrictive. And then you have to look at its application. And of course, in the context of abortion protests, regrettably, things tend to get heated. And so there appeared to be a history of demonstrators engaging with each other, which ultimately led the police to set up physical barricades to prevent the demonstrators from getting at each other. And so in that context, I mean, why isn't the sort of the change in legal posture that occurred here at least sufficient for the district court to have found that the plaintiffs were a prevailing party? And second, I'll ask this now so you can respond. It seems like you haven't really talked about this disclaimer that appears in the consent judgment that the district court is not making any finding on the merits. Is that no longer part of your argument? Are you conceding that that language by itself doesn't really mean anything?
I think given I'll address the second question first, so I make sure and I'll retrace my steps, Your Honor, if that's okay. As Judge Niemeyer referenced and as your question imports, that I do think that I'm always hesitant to tell a district court judge that any line in an order is meaningless, if you will. But on the other hand, I do think that the case law kind of treats that as a reserving of the right to address that. Frankly, I think where my argument really it lies in is that the dismissal of these claims with prejudice and no finding of legal culpability, as in the Farah case, or it's not cited in the briefing, but I'm familiar with the Ray Zadden versus Montgomery County case, where there actually was an acknowledgement by the court of a constitutional wrong. And I think that's the distinction here: a constitutional violation, a legal injury, and that in the Farah case, you have the nominal damages acknowledging that. In this case, we don't have that. And in fact, we go one step
paragraph
forward.
150 of the complaint and several paragraphs thereafter, they say, since August 2018, officers of the police department have instructed Mr. Parks and others associated with Cities for Life that they may not provide materials to persons in vehicles entering or exiting the abortion clinic on Latrobe Drive, even if those persons stop and ask for materials. And then it goes on and gives details, about 3 or 4 details about those things. And the consent decree now authorizes, and they were charged, and that's the allegations, and which are part of the relief that they're trying to avoid. And the consent decree now authorizes them to give to persons who stop and ask for the materials. And so I would think that's pretty substantively a change. It's in a minor part of the complaint because it's the whole complaint dealt a lot with First Amendment, but this was section 19-303 of the charter. And that's all that's addressed in the consent decree.
Yes, Your Honor. And I think, again, where we come down on is that is with the court, or, by agreement of the parties entering that consent judgment, allowing that, again, limited, but nonetheless allowing that conduct to take place, that doesn't predicate a constitutional violation.
No, but the Supreme Court said you don't have to. They've said it twice, maybe 3 times. And they said the consent decree does not have to go that far.
Yes, Your Honor, and I think that's where I am reliant, frankly, on the dismissal of the claims in the consent judgment.
Let's talk about that just for a little bit. And I think Judge Diaz had his first question, so I know I want you to get back to that. So why don't you do that first, and then I'll ask you about without prejudice, so I don't jump ahead.
Thank you, Judge Caldwell.
Yeah.
And if I understood, Your Honor, Judge Diaz's question, it was relating to the application of the picketing ordinance. I'm sorry, I've lost the plot of it.
No, that's okay. And I think you actually answered it when Judge Niemeyer pointed you to sections of the complaint where there were all these restrictions that effectively went away as a result of the settlement and the consent judgment. So you can go on to Judge Quattlebaum's question.
Thank you, Your Honor.
So this issue of the dismissal with prejudice, I mean, I get that, but isn't that, I don't know, I'll confess I didn't really dig into that before, but isn't that a probable result in a consent decree that ends a case? What you had a bunch of claims, you reach some sort of, sometimes it can be a finding, but oftentimes it is a settlement, and each side can have some obligations, and it ends the case so that anything else relates to enforcement of the order rather than going back to ground one and starting the litigation over again. So I guess I'm having trouble understanding why the dismissal of the case, even with prejudice, cuts one way or the other on prevailing when you have an order that replaces allegations.
Thank you, Your Honor. I think looking at the context of when the voluntary dismissals came before, and the plaintiff did not, in the stipulation of dismissal, dismiss various claims towards the end of the Second Amendment complaint. And then to address the court's question directly, I think I would posit that it's just as easily or probable of a result that the court could have been silent as to the claims being dismissed by virtue of the fact that no one is contending that it's not a final judgment in the case, or entered a limited judgment in favor of the plaintiff, again acknowledging the technical legal injury. That would be the distinction, I think, in the broader context of the record, Your Honor, that I would make there. And I would point out too that I think that, and I've seen my time has expired, I'm glad to reserve and allow my colleague to go ahead.
You do have some rebuttal.
Thank you, Your Honor. Thank you.
Crampton.
Good morning. May it please the court, Steve Crampton, on behalf of the plaintiff Cities for Life and others. I would just note for the record that my co-counsel Tyler Brooks intended to be here today, but he tested positive for COVID yesterday. So I hope he's listening in and feeling well. Your Honors, Cities for Life is indeed a prevailing party under this consent judgment because it obtained a judicially sanctioned, enforceable judgment that materially altered the legal relationship between the parties. That is the test that his honors have alluded to that has been crystallized in the likes of the Buchanan case and in numerous Supreme Court cases, as well as Fourth Circuit precedent. Moreover, I think there is a maybe fundamental misunderstanding or disconnect between the city's position with regard to, quote, liability on the merits and our position with respect to how significant the consent judgment's content really is. This was not a judgment on some collateral issue, Your Honors. This was the central issue of Cities for Life's claims regarding the picketing ordinance. And by way of background, I know you're familiar with the record, but for clarity's sake, counsel referred to a settlement agreement that had been reached by the parties back in 2020. Pursuant to that agreement, we settled numerous claims regarding the sign ordinance. And it was relatively late in the litigation, which led to the second amended complaint being filed, that the city began enforcing this picketing ordinance in a manner that resulted in a total ban on vehicle approaches. And just a footnote regarding that settlement agreement, Your Honors, there is in paragraph 3 of the settlement agreement a particular explicit paragraph addressing release and discharge in which the issue of attorney's fees was directly and explicitly set forth. By contrast, of course, the consent judgment says it makes no finding regarding prevailing party, no finding regarding liability on the merits, but as counsel, I think, conceded here at argument, that simply moved the question down, if you will, in the timeline. And consequently, when Cities for Life filed its motion, at that point, the court was, of course, obliged to analyze the issue.
Counsel, let me just explore a couple of things that aren't in this case. You know, we got to decide this in a way that not just resolves this case, but other cases. So with respect to the sign ordinance, there was a motion for an injunction.
Correct.
That was, I think, denied.
Yes, sir.
And I know that doesn't have anything to do with this now, but hypothetically, assume you had moved for an injunction on the picketing ordinance and it had been denied. So there, you have an element of an injunction about likelihood of success on the merits.
Yes.
And the court denies that, and then you reach this compromise similar to what you have here. Is that a different case, or is that a different result or the same result?
I'm not sure that his honor's hypothetical includes a determination on the preliminary injunction. Were you,
The court says I deny the motion for a
Okay.
preliminary injunction.
okay,
So I found no likelihood of success on the merits, but then the parties reach an agreement that has the same benefits you seek here. What's the answer there?
I would suggest, Your Honor, that the answer to that question would be no. We would still analyze the consent judgment that granted concrete relief, as his honors have recognized. In fact, if I may go to a quote from the Lefemini case, I'm not sure I'm pronouncing that correctly, that was actually decided by the U.S. Supreme Court.
Go ahead, yeah.
But was an appeal from this court, in which this court held that there was no prevailing party status achieved, and I'm sorry, I'm trying to find here it is, because it didn't actually provide that material alteration of the legal relationship between the parties. The U.S. Supreme Court reversed and states at page 5, quote, contrary to the Fourth Circuit's view, that ruling worked the requisite material alteration in the parties' relationship. Before the ruling, the police intended to stop Lefemini from protesting with his signs. After the ruling, the police could not prevent him from demonstrating in that manner. That's precisely the sort of change in material relationship that we have here. Before the consent judgment, plaintiffs were totally prohibited from entering the roadway absent incurring a citation or the like.
So,
after the consent judgment.
So I appreciate that. So your point would be you look to the consent judgment and the relief regardless of what happened before, and that's what you look at. So
yes, and I would also offer, Your Honor, the case of Smith against Rivero, and there are several others in this category as well, that the names of which escape me now, but where in fact the parties obtained a preliminary injunction, but they didn't obtain permanent relief. Consent judgment obviously constitutes permanent relief, the end of the lawsuit, as the discussion earlier concerning dismissal of the remaining claims attests.
Let me kind of on the other end of the spectrum. You make the point about a material alteration of the legal relationship. So, and I appreciate your argument that that's achieved here. Is that the concept that would, maybe be a limiting principle on de minimis relief or something that, you do reach an agreement, but it's relatively inconsequential?
I think absolutely, Your Honor.
That's how because, in the real world, people get consent decrees more than that are very much
certainly
settlement type resolutions. And it could be almost a nuisance sort of resolution with some affirmative obligation. And would the material alteration be the thing that would keep that from being a prevailing party?
I would suggest it should operate in that fashion. I do not have a case to cite. I would, however, offer this caution as well, Your Honor. In the damages context, as we well know, under the Farrar case, $1 nominal damages, even when you're seeking 17 million in your ad damnum clause, still constitutes technically a prevailing party. So with that caveat, I do believe that the inclusion of the modifier material to the alteration of the relationship of the parties is a key to weeding out, so to speak, consent judgments that in fact deal with extraneous matters. And again, I would remind the court that this, as Mr. Parks, the leader of Cities for Life at the time, testified, this was the most important component in the ministry of Cities for Life. It is, as the U.S. Supreme Court recognized in the McCullen against Coakley case, the one-on-one conversations in the context of a pretty heated, very short time frame kind of interaction outside an abortion clinic is crucial to the First Amendment rights, both of those who, like Mr. Parks, have a message to share, as well as those in the vehicles that actually have a right to receive that information. So we have not only the leafletting, but also the oral conversation at issue, which is, of course, core First Amendment conduct. And in that sense, again, I think the city fundamentally misunderstands the significance of the consent judgment insofar as its vindication of those First Amendment rights. Yes, it did not explicitly state that Cities for Life was a prevailing party. Yes, it did not explicitly state that the city was liable. But as the district court pointed out, quoting the Mayor against Gagne case from the U.S. Supreme Court, quote, "It is
I
customary."
don't understand your last statement. You said the district court didn't say they're a prevailing party?
No, it did not, in the consent judgment, address prevailing party.
Does that
Your Honor.
make any difference? I mean, the court issued an order and said they're the prevailing party, and the court was interpreting in its own order.
Absolutely right. And I think that was obviously correct, and we stand with that. What I'm addressing, Your Honor, is the city's contention that somehow there's significance in the fact that the consent judgment itself was silent on the issue of prevailing party.
Well, it seems to me that a prevailing party is somebody who, I mean, the common sense words, who prevails on the claim for relief in some material manner. And Supreme Court, I think Judge Quattlebaum is centered on what the Supreme Court, I think, is interested in, a material alteration in the relationship. And so the question is this a material alteration in the relationship? Your colleague says it's a draw.
Correct.
And you say it's a material thing, and that seems to me the centerpiece of whether they're the prevailing party in this case.
Absolutely, Your Honor. And again, I think the case law makes very clear what you just articulated. Any material alteration on any issue constitutes grounds for finding a prevailing party. It's precisely what we have here. The fact that Cities for Life was willing to forego, for example, the district court chastised us for not obtaining declaratory relief. Ultimately, as the district court noted, we have an effective injunction against the city's application of this overbroad total ban on approaches to vehicles. That is enormously significant in the world of Cities for Life. Whether those other issues were dismissed or not is maybe a prudential concern. And I think, in fact, it was here. But as the earlier discussion with opposing counsel noted, there are several conditions now imposed on the city. One, plaintiff can approach, albeit under some conditions. Two, the city must leave open some space between those barricades that it has employed periodically to separate the parties. Three, if a plaintiff or its volunteer approaches and somehow missteps, so to speak, under these rules, the city doesn't immediately pounce and issue a citation. Instead, it must issue a warning, sort of like in the trespass context. You have a one bite kind of rule, or 2 bites really, because you get a warning. And fourth, and very significantly, because it's a consent judgment with the judicial imprimatur of the district court, the plaintiffs may enforce any violation of that consent judgment by a contempt motion, rather than having to start from scratch with a brand new lawsuit. Those are significant points, which I think the city, frankly, has no answer for. It is absolutely fundamental that we went from, and the city's own brief admits it, no approaches whatsoever to approaches, albeit under conditions. And those so-called safety conditions are, as I would say, immaterial in the analysis of whether we are in fact prevailing parties. Now, briefly, and with some trepidation, allow me to turn to the issue of the Cities for Life asking this court to revisit the court's finding on the amount of fees and the reduction by a flat 75% across the board reduction of fees.
There's a problem with that.
Yes, Your Honor.
Procedural problem, serious.
Yes, there is.
It seems to me that anything you advance below for your position for the district court, you can review, even if the district court didn't address it. But if you're seeking to change the judgment, then you need to file a cross appeal. And the procedures are you have to file a filing statement and you have to file a cross appeal, and the filing statement has requirements in it. And you are seeking to change the judgment. The judgment here was for some $33,000, whatever it is in costs, and you
Yes.
want more.
Yes.
And I think that's as clear as a bell for requirement of a cross appeal. The rules even address cross appeals, but it's a little, our local rule requires you to file a filing statement if you're going to file a cross appeal. And the traditional distinction is when you're seeking to change the judgment.
Understood, Your Honor. And I would point out only that the Fourth Circuit has made it clear in the likes of Tug Raven and other cases that requirement for filing a cross appeal where this court has already obtained jurisdiction by virtue of the appeal by the opposing party is not jurisdictional. It is a rule of practice.
Yes, of course it is. And then as you've pointed out, when there's a big injustice, we've stepped in. And that's a discretion of our court. But I think aside from the notion that there was a big miscarriage of justice, it's a hard row for you to hoe. But
No, I appreciate that, Your Honor. I would, at the risk of maybe belaboring the point, raise for the court's consideration one Fourth Circuit precedent that we did not cite in our brief, and it's Brodziak against Runyon, 145 F. 3rd 194, Fourth Circuit 1998. And in that case, the district court had reduced by 60% across the board, based the fee request, based on the plaintiff in the district court's view, prevailing on only 40% of his claims, very much like what the district court here did. This court reversed that determination, finding it clearly wrong, even under the abuse of discretion standard, because the U.S. Supreme Court in the Hensley against Eckerhart case made it clear that the determination on fees cannot be made purely on a mathematical comparison. Quote, this reasoning contravenes the principle set forth in Hensley that awards of fees and costs should not be based simply on the ratio of claims raised to claims prevailed upon. We would suggest that after some months of cogitating on it, that appears to be what the district court did here.
And Mr. Crampton, just to be clear, because you didn't cite the case in your brief, that I don't think you're suggesting this, but was that a case that the court took up sua sponte without a cross appeal being filed?
It was not, Your Honor. It was not.
Okay, so you're still stuck with this jurisdictional problem, right? Just
Yes, sir. Yes, sir, we are.
all right. Thank you.
If there are no further questions, we would urge the court to affirm the finding of the district court as to prevailing party status. And we would ask that the court consider making an exception with respect to the 75% reduction. Thank you, Your Honors.
thank you, Mr. Crampton. Mr. Peterson.
Just briefly, Your Honor, in rebuttal, one statement that was made by my colleague opposite struck me that the plaintiffs can now enforce the consent judgment as to the city, and I think I cannot argue with that. However, I think it's worth to my earlier point of a legal draw. So can the city now enforce the judgment as to the plaintiff? And again,
What part? In other words, you've got the statute still in place. And so you can enforce the statute so long as you don't compromise the exceptions made in the settlement and the consent decree. But why would you ever go to the consent decree to enforce something? You would have to always go to the charter. I mean, there's a city ordinance, wouldn't you?
I think we could, and perhaps in most cases should, but as with respect to the plaintiffs entering into an agreement, this agreement with the city.
What provision of the consent decree? I've read the consent decree, and it didn't seem to me that there were rights being granted to you that would be enforceable beyond what you already have under the statute.
Your Honor, I think the fact that it very clearly sets out the safety issues that were testified by the various police captains and majors on the scene, just particularly in the context of these barricades, now that we have to obviously put a break in the barricades to allow for the approach, Your Honor. However, I think that the fact that we have memorialized in a judgment the ability to hold plaintiff to account under the contempt powers of the court, just as, for example, the plaintiff could restart file a lawsuit against us. They will always have the, section 1983 as well. So
What if, assuming you're right there, why isn't that kind of baked into the, the reduced fee award? Assume there is some element of give and take. Judge Niemeyer makes a good point. It may not, that may be debatable, but even if you're right to some extent, if the plaintiff achieves some meaningful part of relief and as part of a consent decree that gives the city something too, why isn't that just, baked into a reduced fee award?
And I think it's in addition, one of those in addition to or alternative situations, Your Honor. I wouldn't disagree with the court that is baked in to the court's analysis. I would just posit that the fact that there's a legal change in the legal relationship, notwithstanding Your Honor's well-taken concerns about whether we would just be able to apply the ordinance authority or go back to the court on some of these safety concerns, if you will, that we also experienced what we contend is a positive change in the legal relationship between the parties. Again, going back to my original point at the top of my argument that this was at best for the plaintiff a legal draw. We do think we would be able to use the.
You also got rid of a lot of litigation and saved a lot of fees.
Indeed, Your Honor. I have no disagreement on that. Thank you, sir. And that's all of my arguments.
Well, thank you very much. This is actually an interesting matter. You want to take a?
I'm fine, but okay, whatever y'all want to do.
Judge Diaz, you okay to go on to the third case?
I am if you are.
Sure. Okay. We normally come down and greet counsel. Judge Diaz wouldn't be here, but I'd shake hands for him with my left hand and yours with my right hand. And thank you for your arguments. It's a tradition of our court that we're not giving up, but we're still following the COVID protocols right at this point. So next time you come, I hope we can greet each other more personally. But thank you for your arguments, and we'll proceed on to the next case.
Thank you, Your Honor. Yeah.
Daniel Scott Harawa, on behalf of the appellant Arthur Lee Sanford, I'd like to reserve 5 minutes for rebuttal. Your Honors, the state concedes that it violated habeas rule 5 in 2 distinct ways. First, the state concedes that it violated habeas rule 5C when it did not attach transcripts to its answer, despite citing transcripts throughout its answer. And then the state concedes that it violated habeas rule 5D when it did not include all of Mrs. Sanford's briefs and motions that he filed in state court contesting his conviction, including his full petition to appeal that was filed in the Virginia Supreme Court, along with the attached exhibits. Under this court's reasoning in Thompson v. Green, this court must reverse. Now, the state nevertheless argues that the district court did not abuse its discretion in relieving it from complying with Rule 5. But that argument must fail for at least 2 reasons. First, the district court never acknowledged the state's failure to comply with habeas rule 5, and therefore there's no discretionary ruling at play. But second, the language of habeas rule 5 is mandatory. Thompson v. Green makes clear that compliance with habeas rule 5 is mandatory, and the state does not cite a single case in which a court held that a respondent did not have to comply with the mandatory rule. So therefore, it would have been an abuse of discretion if the district court had excused the state from complying with the rule. And ultimately, Your Honors, and with respect to my friend on the other side, the state's litigation choices in this case created somewhat of a mess. Because the state did not attach the necessary documents to its answer, it's not clear that the district court had those documents before it when issuing its ruling. This court doesn't have the documents now for it to review the district court's ruling. And Mr. Sanford never.
Say we don't. We don't. I mean, the
Yes.
circuit court habeas, we don't have, do we?
You don't have any of the state habeas records, Your Honor.
It's surprising to me. I tried to figure this out. The district court clerk said they sent us everything they have. And our clerk says, and asked several times for the circuit court, and we don't have it. So the long and short, it looks like the district court didn't have it. Now, the question is, when the district court said it was referring to the circuit court record, it only cited the state's response. Every citation is the state's response. It was not to the record itself. And so there is somewhat of a mystery here. My guess is the record's still sitting down there in the circuit court somewhere, but you haven't solved that problem yet?
Your Honor, it's very much a whodunit or a case of the missing records. I mean, I think, and I believe, and the state can correct me if I'm wrong, I believe the state said that the circuit court records are in Newport News. So I think
but that was, they were supposed to be transmitted to the federal court.
yes, and Your Honor, yes, the district court needed those records to issue its ruling, and this court certainly needs those records to review the ruling. The state hasn't made, as far as I'm aware, any.
So, Robert, can I ask you about that, sir, about how this process should work? So the district court, in this case, did make a request that as part of the order that the records of the state proceedings, if pertinent and available, be forwarded to the clerk's office. And it's not clear whether or not that actually happened. But is that typically the practice? I mean, in the Thompson case, I think the way the district court, I don't know that district court specifically requested records. It may simply have relied on the response filed by the state and whatever records the state would attach to its answer. So if what had happened in this case, if the court simply had relied on the state attorney general to submit whatever relevant records it deemed necessary to dispose of the case and attach them to the answer, would that have sufficed?
I think that would, if I understand your question, Your Honor, and I want to clarify what happened in Thompson and explain why it's similar to what happened here. So in Thompson, the district court did issue a similar order asking the Attorney General of Maryland to forward any pertinent state court records along with its answer. And there, the Attorney General of Maryland just didn't send the entire case record to the court. It created a set of exhibits and filed them separately from its answer. And so, this court—
In addition to the entire record, is that what you're saying, or just that was the record?
That was those were the pertinent records that the Attorney General identified in response to the court's order for records.
But apparently what happened here, at least what's represented here, is that the entire record was delivered to the district court. Apparently not, but that was what the court anticipated would happen. And then the state, in its answer, attached exhibits, didn't attach the transcripts that it relied on, and the exhibits themselves were incomplete. Is that right?
And yes, Your Honor, and if I can just say, I mean, maybe the state is in the practice of having the entire state court record forwarded to the district court. But I think that doesn't, the point we're trying to make here is that doesn't excuse the state from complying with habeas rule 5 and its dictates. And I mean, and that is really for the district court's benefit. we don't want district courts to have to sift through boxes of records. I don't know if this court has seen the box of records that the district court filed that has never been docketed anywhere. I mean, the whole point of habeas rule 5 is that it's a funneling system where the district court is pointed to the most pertinent documents. And so I don't think the state can say, well, we had the entire record forwarded, even though the state said, or the district court said, only send us the pertinent records. And then the state said—
district court didn't say that here. The district court sent us the important pertinent record on the trial, but it also asked for the habeas files.
Yes.
Both in the state and the upper court. Now there is a certificate of transmission from the Supreme Court, a few documents there. I don't quite know how that, if that's in the file. Anyway, what I do know is we don't have the habeas records, and it looks like the district court didn't have it.
Yes, Your Honor. And I think that is the only— I mean, the state tries to transform the district court's single sentence that I've reviewed all of the records. But I don't think given—
Yeah, but every citation the court gave was to the court, the government's response. They did not, the court did not cite to any record.
Yes.
To indicate that. That to me, my guess was just a statement that it assumed it.
So, Counsel, I'm trying to, I may be jumping ahead a little bit or not, but is it your position that if the state had complied with subsection C and D, the issues about, would you have the information that you need? Would that be satisfactory? Because we have these issues about private docket entries and, the whole transcripts from all the proceedings. I'm trying to figure out if that effectively is satisfied by your view of what's required under 5C and D.
I think it is, Your Honor, usually. The one caveat I think would be, to the extent the court starts relying on other information outside of what would be attached in exhibits, then I do think a petitioner would still be hamstrung in their ability to respond to claims or to respond to the district court's ruling. But I think in most cases, the state complying with the rules would alleviate any concerns of the type that are present here, given the state of the records facing this court now. And Judge Niemeyer, I think your point is exactly right. And that's why I think the state's argument that the one sentence in the district court's order saying, I've received all the records, doesn't hold water, or this can't be sure that that's true, given that this court doesn't have the records.
Well, my take on it, based on what we have, is that the court assumed it had the full records because and relied on what the state filed in its response. But it relied only on the response, nothing what was in the habeas files. And so the response is the issue under Rule 5. The record is at issue under the rules, the court's order that directed the state to directed it all. To me, it looks like this case is unintentionally messy because of the question of whether the district court had all the records and whether the petitioner had the records necessary to respond. It may not make a difference, but this is a pretty serious case, as I recall, the underlying case. And so I'm interested in hearing what the state has to say about the record issue. Whether it's harmful or not is another question. In the back of my mind, it looked like at least some of the transcripts your client had, but he doesn't know what was being relied on by the state and what was being advanced and what transcripts in particular. But
Your Honor, I just quickly like to make 2 points. I mean, we do know that Mr. Sanford didn't have all of the records because he moved this court after the state filed its response. He moved the district court for a copy of the state court records explaining that he didn't have those records. And that's at JA 224. And so we know he may have had some of them. There's no finding on what records he had versus he didn't have. But I think on this record, the fact that he asked the court for records and the court denied it, we know he didn't have at least some of them. And-
So, Mr. Arwala, I'm sorry to interrupt you, but so to follow up on that, and you raised the point earlier about this being Rule 5 being a funnel approach. And then you in response to Judge Quattlebaum's question, you indicated that you had a caveat to that, and that being that if the district court relied on something outside of the state's answer, that would be problematic. And I guess that's the concern. That would be the concern in every case, right? Because if the state records are submitted in full to the district court, but the state relies on a portion of the record in its answer, and then the district court goes beyond that response and looks at the entire record to dispose of the case, the petitioner is in a bind because he doesn't have the entire record. It's not like a direct appeal where you have a JA, which is sort of a funnel in a direct appeal, but both parties have access to the entire record. That's not the case typically in this scenario, right?
Your Honor, that's right. And I think the practice of just sending the entire records is problematic as a general principle. Because as we see here, documents may go missing. We don't know what the district court relies on. We know the petitioner doesn't have them. All I was trying to suggest to Judge Quattlebaum is that I think in most cases, it probably is the case that if the respondent is focusing on certain documents and the petitioner has them, the petitioner can respond. But I do think, and it's a question this court need not reach now, but I do think in the event that the district court starts relying on things that the petitioner doesn't have, that creates a separate issue that this court would have to address. Because
I'm not sure in this case we can determine what the court relied on. It looks to me like the court relied on only what the state included in its response, even though that response didn't include everything.
yes,
Although that's not totally clear because I think, I don't know. But the problem of the record, there's no requirement that your client be given the record. But in this case, the court ordered the whole record and purportedly relied on it. And then your client didn't know that the record was up here because it was done with a out of court docket entry. But I'm interested in hearing from the government on this.
I hear your urging, Your Honor. So if I may reserve the rest of my time and I can turn it over
Okay.
to my friend and address remaining questions on rebuttal.
Thank you.
Thank you.
Ms. Minix? You've heard most of my questions.
Yes, Your Honor. Let me. Good morning, Your Honors, and may it please the court. My name is Leanna Minix, and I represent the Director of the Virginia Department of Corrections in this habeas corpus appeal. I have heard the court's concerns, and before I begin, I would like to just note that I realize this case is unusual in some ways, and I understand the court has questions about the treatment of Rule 5 in this case, and more broadly.
Actually, I'm concerned not only about Rule 5, but I'm concerned a little bit beyond that because the court reviewed the petition, and it's not required to have the records, but it issued a show cause order, and in connection with that, directed that the state provide all the records, including the circuit court habeas file. Apparently, a lot was shipped up to the court, but no one knows where the circuit court habeas file is. Now, the question is that would be pretty important for a federal court to be reviewing, applying the 2254 standards of what was decided, what wasn't decided, what was the ruling, and what was before the court, and this type of thing. And the court said it had the records. I think it said it, but it looked like just a generalized statement because every statement it made in its opinion refers to your response. That's one issue that bothers me. And the other issue is the response did not have all the records attached that Rule 5 requires. And none of this is a terribly serious thing, but it is a procedural mess up. It seems to me we ought to fix, shouldn't we?
Yes, Your Honor. And I'm happy to address the court's concerns about the records that are now absent in this case.
No, we don't have our clerk has searched and checked with the clerk of the district court. And so I don't know, has anybody checked with the Norfolk Circuit Court?
Yes, Your Honor, I did. I personally investigated the record in this case, and I went to Norfolk Circuit Court. I reviewed the record there. I had a hunch that it had been inadvertently returned. And I'm happy to, I would point out that this case, after the district court entered its original memorandum opinion granting the respondent's motion to dismiss, this case come up for review on direct appeal before this court. It was affirmed on direct appeal by this court, and this court entered an order, and this is at JA 273, saying that it had independently reviewed the record. And so I would submit that on direct appeal, there's a presumption of regularity that attached to the district court's findings, that it had reviewed the record, and to this court's finding that it had independently reviewed the record. As to the communications between the clerk's offices, I would submit that those communications came after the petitioner had filed his Rule 60B motion. And I'm not exactly sure where the records were.
Story about the failure to include the materials required by Rule 5. There seemed to be quite a bit omitted.
Your Honor, and as we admitted on brief, we did not include the transcripts under Rule 5C.
It didn't include his whole petition. As a matter of fact, his petition was quite lengthy and had exhibits, and that wasn't included.
I agree, Your Honor. We also did not include a complete copy of his petition for appeal, but in looking at the petitioner's complaints below, and I would point to his Doc 12, which is in the joint appendix, his response to our motion to dismiss, as well as his Doc 16, which was his motion for additional records. The petitioner never complained that he did not have access to those documents. And I would submit that in considering.
Well, that's not totally clear. He cited several things that looked showing that he had some materials, but he also complained that he wasn't getting records and he had moved, and he continually complained to the courts that he didn't have records. And we look very hard. It'd be nice to handle this on a harmless error type of situation, because but what's the problem but just letting the district court collect all the matters and see whether it has any different view based on the presence of all the records?
Well, Your
District
Honor,
court tells us they didn't have the record.
No, I would disagree, because I do think that the district court found it had the record.
It made the one statement, and
that was an order.
its one statement was sort of backed up in the very next sentence. All of them were based on what you said in the response, or not you, but the filed.
Well, Your Honor, I would point to Doc 33, which is the court's order.
I know it's in the order. But my guess in reading and putting it all together, the clerks are pretty careful on these things, and there's no transmission back to the state. They would have a clear transmission order box in it. They did not have an itemization. They had 2 entries of the records, which did not itemize them. They talked about the number of folders, what they received. And I don't know if the state habeas is defined by those folders. Have you compared the number of folders in the state habeas with the docket entry? The clerk has counted the manila folders and counted this.
I examined the record that was here in this court.
The docket entry in the district court itemizes just by folder what it received.
I believe
My question is, does that itemization match the nature of the record in the circuit court for Norfolk?
Based on my review of the circuit court record in Norfolk, there was one habeas corpus file. And then there is, Your Honor, I would actually have to review my notes before I make that representation. But I did look at the entirety of the file in Newport News. I certainly.
Would you object to having this case go back to Judge Brinkema and say, get all the records before you and look at the arguments in view of those records? And I think at the least, she should allow you to file an amended response so that the petitioner can have all the materials on which you're relying in order to prepare his arguments.
I would urge this court to affirm on the merits. If the court were to decide that it was appropriate to remand this case, I do think that is the appropriate scope of the remand. If the court reached that conclusion, but I do think there is more than enough evidence before this court to affirm on the merits. In addition,
there's evidence to affirm on the merits, but the petitioner would say we didn't have all the evidence.
Well, and
his position.
But I disagree with his position. And I'm happy to point out that I think that looking closely at his objections below, the petitioner was complaining that he kept saying that the court did not have a complete factual record before it. And that was the petitioner's way of, even in his first federal filing, before anybody had filed anything in response, of complaining that he had not received a state evidentiary hearing. He wanted the opportunity to present additional evidence. And so he urged the court to grant his federal habeas petition on the ground that it had an incomplete record before it. He wanted a federal hearing. He used that language in his federal habeas corpus petition, and he echoes that language in his Doc 12 and Doc 16. The petitioner was concerned about the court having the complete record before it, but he never complained that he did not have access to these records. And so while, again, we have admitted that we did not comply with these requirements in Rule 5, this case is not like Thompson, where the court held that Rule 5 provided for no discretion at all. No, excuse. I'm sorry. I would like to.
If it's not complied with, it was a mandatory violation.
Excuse me. No discretion as to the respondent's practice of not providing petitioners with copies of parts of their actual pleading. The failure of the Maryland Attorney General's office to serve its exhibits on a petitioner.
I understand that. That's a little slightly different, but here the petitioner was served, but he was served with only a part of what the state was required to provide. The Rule 5 requires a list of things to be attached to a response, mandatorily. They were not attached. What was attached was deficient, as you've acknowledged, and that was served on him. So he has that. But he says the state relied on materials that it didn't attach, including the transcripts.
Well, Your Honor, I think looking at the rule, looking at the language in Rule 5C, shows particularly why this issue is subject to an abuse of discretion standard, on top of the fact the petitioner did not raise in looking at his.
In that statement, what's the argument?
Well, looking at Rule 5C, the rule first says that the respondent must attach parts of the transcript that the respondent considers relevant. So that is an exercise of discretion on the respondent's counsel's part. And I agree that I'm not saying
explicitly relied on portions of the transcript and didn't attach it.
Yes, Your Honor, and I acknowledge that. But the second part of the rule allows for the district court to also exercise its discretion in ordering us to provide additional transcripts. And so while the ruling
additional transcript, but how about the initial transcript that was omitted and not provided to the petitioner?
Yes, Your Honor, and looking at the text of the rule, I think that the text of the rule is at issue here. And so while the court said in Thompson, it was reversible error there, here, this rule provides for the exercise of discretion by the district court. And the district court could look at the petitioner's first filing as well as his state court filings.
The court did not even acknowledge that the transcripts were not provided in the response. And he complained. He complained. He says, I didn't get any transcripts, and the copy of my petition was omitted from the district court. The 24 pages were provided, but the remainder was not provided, and the exhibits were not provided. And so the court didn't acknowledge that. Now, the question is, if the petitioner's entitled to that before he makes his defense, and you don't comply, it's not a question of discretion. He didn't ask for additional transcripts. He only asked for what was included in the response.
Your Honor,
the response doesn't require the whole transcript. It just requires the transcripts you relied on.
Yes, Your Honor. And in looking at the citations that the petitioner cited in his Doc 1, his first filing, and the citations that we cited, there is significant overlap. And so
I noticed that, and that's very troubling. I don't know what he had. He had some transcript of some kind. And the question is, do we conclude that he had all the transcripts? Do we conclude he had the transcripts that you were referring to? There is some cross-reference there.
yes, Your Honor. And
Why do we sort that out on appeal?
well, again, I would submit that the presumption of regularity has attached, and
There's no presumption. We know it's irregular. We already know it's irregular.
Your Honor, there is enough evidence before this court to know that the district court did receive and review those records, in addition to the district court's finding and this court's order on direct appeal. There are several documents included in the supplemental joint appendix.
Counsel, why isn't, I'm going to move a little bit beyond Rule 5. I mean, why is a petitioner not entitled to know what the district court receives in response to a request for documents?
Are you referring to the transfer of the whole state record, Your Honor?
Yes.
I heard the court's concerns about that as well. The transfer of the record, let me just back up a little bit. This is a ministerial act that our office is often, frequently, in almost every habeas corpus case, directed to coordinate between the clerk's offices. We are never the custodian of the records, consistent with the court's order. The records are forwarded between the state court clerk's offices and the federal district court clerk's offices.
Right. And my question was not really to get to the ex parte issue. I appreciate that issue, but there's docket entries that are private. So whether it's ex parte or not, that's not really my concern. I mean, the petitioner doesn't know, as based on what happened here, what went to the court.
I think that the petitioner I recognize that the ECF notifications are often issued about the transmission of the state court records, and we receive those frequently. But the petitioner received notice in several ways. I would point out that in our filing, we noted that pursuant to the court's order to respond, that we had requested the transmission of the state court records. The court also noted that it was ordering us to coordinate the transmission of those records. And then, of course, the court made its findings. And I do think that the court's findings were in direct response to the petitioner's complaints in his Rule 60B motion.
So so taking that further, it sounds like it's your position that a petitioner is not entitled to some actual notice when the court receives documents as to what documents it receives and might be relying on to review the petition?
Well, Your Honor, I think the point of notice, for example, here, the petitioner was issued a Roseboro notice. I don't think it's in the joint appendix, but it's Doc 10 on the district court sheet. Provides notice to the petitioner about what he can do next, what the court may do next. But in terms of the receipt of the records, I don't see what the notice would do for the petitioner. And I would also—
He could then request what was transmitted. He could request a look at what the court file has. He could go to the courthouse, not him personally, whoever represents him, could go to the courthouse and look. The whole point is, I didn't understand why there's a secret docket entry. The public docket goes from docket number 9, say, to docket 11 and skips 10. And it goes from 12 to 15 and skips 14. I mean, it's a peculiar practice, and the public doesn't know that the court received the documents, and neither did he. And now the question is, there's a lot of usefulness in knowing that. He could go see whether it's complete. He could get a look at materials, request copies.
I don't think there's anything here to indicate that the petitioner was denied access or even requested access.
Wasn't provided with knowledge of it.
I think that's maybe correct, but had he known, he might, as Judge Niemeyer says, wanted to say, hey, it says you got the whole record. I want to make sure, nothing's missing. in this case, almost, I recognize there are multiple things that could have happened here, and I don't know. But one explanation could be that the court didn't have the whole record. I know you think that's not right, and you may be right. I certainly don't know. But doesn't a petitioner, I mean, the habeas burden is very high. We talk about that all the time in our cases. It just seems like we're doing a whole bunch of stuff here when, it seems fairly basic that a party should be entitled to know what goes to the court and at least have the ability to go take a look at it.
Well, and Your Honor, I don't think there's any indication that the petitioner thought that he was even being denied his own access. I understand he was concerned about the court having those documents. And I think that's a separate issue because the petitioner never complained that he did not have these documents. He cited his own transcripts in reviewing the state habeas record. I think that my investigation revealed additional support for, and I can provide it to the court if you are interested in it, but in knowing that the petitioner had access to those documents. The exhibits that he complains about are records that he had previously filed. And so, yes, Your Honor, I'm sorry.
No. Are you saying from the state proceedings, he had his own copies? Is that what you're talking about?
Yes, Your Honor. In the state habeas proceedings, the petitioner filed his own transcripts as exhibits.
Okay, thank you.
And I recognize that that record's not before this court, but I can provide that information to the court because I looked at it.
I think I don't dispute that he would have had some or all or a lot. I mean, I don't know what that is, but I think that's a fair point that, at the end of the day, he might have had a lot, but he might have had a lot and still wanted to see what the court had to see if it matched up.
Well, and I think that falls outside of Rule 5. I would
that may be true.
And I would point to this court's body of law saying that the constitutional standard, which is not encompassed in Rule 5. Rule 5 is a procedural rule of court. It is different. The constitutional standard, this court has issued multiple cases and opinions saying that the petitioner must make a particularized showing. With my remaining time, I would like to touch on the fact that the records are regularly transferred between the courts. They are not redacted. It is not appropriate for them to be uploaded to the public-facing docket because my office is never the custodian of those records. The clerk's offices would be required to redact those records in accordance with the local and civil rules of procedure. And we never purported to file any of those records as exhibits in this case. And so the petitioner was not entitled to a copy of his record under Thompson, under Rule 5, and he's failed to meet the constitutional showing. Are there any other questions or concerns that I can address from the court?
Okay, thank you.
Thank you. I would ask this court to affirm.
Yeah, thank you. All right, Mr. Harawa.
Yeah, thank you, Your Honor. A few quick points. So this court was abundantly clear in Thompson v. Green, and I can read, this is from page 271. The Attorney General raises on appeal other contentions that he is not required to serve exhibits because they should already possess the documents or have general knowledge of those contents. This court rejected that argument as borderline frivolous and said, and I quote, "It is irrelevant whether a petitioner can demonstrate need to the court or whether he already has the documents." So that argument has been considered and squarely rejected by the court. I also would like to point out that Mr. Sanford could not have been clearer in his documents that he was missing some of the records or that he was unsure that the court had all of the records. So if you look at page JA 212, which is his response to the motion to dismiss, I quote, "The respondent fails to comply with Rule 5B, 5C, and 5D governing Section 2254 cases." So he points out very explicitly that the state failed to comply with the habeas rules, both 5B, which is addressing his contentions, C, which is the transcripts rule, and D, which is including his briefing. In his motion to order records, he says, because of respondent's failure to comply with federal rules of civil procedure 5, he asked for additional records. And that's on page 224 again of the joint appendix. And so I just don't think it's fair to categorize Mr. Sanford's arguments here as anything but, I don't have what I need to litigate.
That motion, he filed a specific motion to order records.
Yes.
And that motion was denied without explanation, except for one request. And I didn't see that request for It was a request for some movie transcript.
Yes, and Your Honor, if you look at,
That's the only thing that was denied, and the rest wasn't addressed.
yeah, and the court just didn't address anything else. And then if you look at his Rule 60 motion, he is very clear that he is unsure that the court has all of the records before it, that it needs to issue its ruling, in part because of the state's Rule 5 violations. And I mean, to the extent the state is trying to make a harm argument, even though Thompson said there's no harm showing required, it is hard to say this is harmless, given the fact that A, there's no finding on this record that Mr. Sanford had everything. But B, this idea that maybe some of the records were sent inadvertently back, like that's just not the type of guesswork, respectfully, that this court should have to engage in.
So could I ask you about an issue that was raised right at the end of your colleague's argument, and it's addressed in the briefs about, if like here, there's a request, by the court for documents in addition to the other parts of 5C, and the state, as they do here, sends or undertakes to request that the state court send the complete files. Then there are contents of those files that there may be confidentiality issues to. And the state saying, look, I mean, they're not our documents. We're not custodians. We don't want to be responsible for any violation like that. What's your response to that? Are you seeking to have them do that type of review, or are you saying, look, we're not asking for them to be filed. We just, we need to know what they are and have an opportunity to review them, and whoever files them can do whatever needs to be done from a confidentiality standpoint?
Sure, Your Honor. I think there are a few points in response to that question. The first is, I think notice is important. And Mr. Sanford did not even know that the courts forwarded the document. There's nothing in the record other than the order saying to forward the documents until the district court, issued its ruling now saying, I have this internal docket sheet. I received these documents. So I think there's a very real notice problem. Then if you look at the district court's order for the records, which is on page 60 of the joint appendix, the court makes clear that it says send the records if pertinent and available. And I don't read that language to say just send everything to me. I think that necessarily requires some calling on the state's part. Now, I don't know the relationship that the state has between state courts and district courts, but what I do know is that this is one of the key reasons why habeas rule 5 exists, is so that the necessary pertinent documents can be picked from those records and served upon the court, can be docketed and sent to the petitioner. I don't want to make any kind of broader representations about the entire state court record being needed to be uploaded to PACER or anything like that. But I will say that in a situation where it's clear the state has an obligation to do this, the state didn't meet its obligation, the fact that it just had all the records sent can somehow excuse its failure to comply with habeas rule 5.
Mr. Aurora, to follow up with that, so if we were to agree with you that this case needs to go back, what is the precise remedy that you're asking the court to direct?
I mean, so, Your Honor, I think first we need to reconstruct we need to figure out where the records are. And then I think the state needs to file an answer that is compliant with Rule 5 once the records are found. And because of the missing records and because of kind of the complications or the mess of this case, I would respectfully ask that this court include that the district court appoint Mr. Sanford counsel to help him navigate what goes on if this court were to remand the case.
Well, I guess what I'm asking is, with respect to Judge Quattlebaum's question, are you asking for the court to direct service of the entire record on your client or his counsel, or would you be satisfied with I think at the very beginning of this argument, you indicated that it would be up to the state to call and decide what it deemed to be relevant and pertinent, attach that to a new answer, and have that served on the petitioner to start the process anew?
I'm sorry, Your Honor. I think there are two responses. I think there needs to be a compliant answer file that complies with habeas rule 5. Now that we know that the district court has the documents, I think Mr. Sanford's counsel should have access to those documents and should be able to take from them.
Doesn't have the document.
Or now that,
The record that the district court had, the files the district court have, we now have. We do not have the habeas records.
yes,
So for the district court to have the full vote, we have to make sure that Norfolk sends, if they didn't send it, sends it up, or resend it if they did send it, but send up the habeas file to the district court. We have to send back our file to the district court.
okay. I'm sorry, I meant, let me be clear. So I think first, this court needs to transfer what it has back to the district court, which I appreciate this court actually let me comb through the files. And then I think we need to figure out where the state trial habeas records are in Norfolk and have them sent to the district court. There are also state appellate habeas records, which are missing, that need to be located and sent to the district court. And then I'm not saying that the district court necessarily has to upload everything to Pacer, but I do think that Mr. Sanford and his counsel needs to have access to those documents if the district court has them and may potentially rely on them. If there are no further questions, we respectfully ask for this court to remand for further proceedings. Thank you, Your Honors.
Do I understand your court report appointed?
Yes, sir.
Are you going to stay with him when it goes, if it goes back down?
I can stay with him under the limited nature
Oh,
of my
see.
clinic that I
Your
represent.
appointment is for the appeal?
Yes, sir.
I want to recognize your service to the court and thank you very much.
Thank
And
you.
I want to thank both counsel for their arguments. As you know, we normally come down and shake hands, and we would come down and shake hands and make all amends that any injustice we may have already perpetuated. And thank you for your arguments. Next time you come, we'll be shaking hands, but thank you very much for your arguments.
Look forward to that.
We'll adjourn court for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.
About the story.